for a subject matter that is localized So as I'm saying, the distinction between mandatory and discretionary jurisdiction is that the choice of jurisdiction rule will give conditions or requirements in order for the court to be able to entertain in matters of right. So when those conditions have been met, it is said that the court is exercising jurisdiction as of right, or that the jurisdiction is mandatory. But it does not mean that a defendant cannot play the court to stay that matter. So when you want to play the court to stay a case which it has jurisdiction as of right to entertain, what you are praying for is discretionary exercise of jurisdiction, of power to decline the jurisdiction that the court has as of right. But that is not the only type of discretionary jurisdiction. There is the other type of discretionary jurisdiction that is called assumed jurisdiction. What this one means is that an event has occurred within the territory of the forum of action. Ordinarily, the court of that territory should be the one to entertain the matter. But because the choice of jurisdiction rule requires that the plaintiff must be able to serve the defendant within the territory, and that has not been possible. So by our choice of jurisdiction rule, the court will not be able to entertain the matter. The only thing that can be done is to go and serve a notice of the writ on the plaintiff, on the defendant abroad. So when the plaintiff now prays the court to allow him to reach the defendant or to serve notice of the writ on the defendant abroad, we say that what he's doing is that he's praying for discretionary assumption of jurisdiction. That is, he's praying the court to assume jurisdiction on the basis of discretion. So there are two types of discretionary jurisdiction. The first one is the discretion to assume. In circumstances where ordinarily the plaintiff would not have met the requirement for jurisdictions of right. The second one is the discretion to decline in circumstances where it will be proper to say that the court has jurisdictions of right because the plaintiff has met the requirement. So those are the two types of discretionary jurisdiction: discretionary assumption of jurisdiction, discretionary declining of jurisdiction. So let's start with the first one. Discretionary declining of jurisdiction, otherwise called assumed jurisdiction, is when a matter which is otherwise connected with the territory, but the plaintiff is not able to serve the defendant within the territory. Maybe the defendant, after committing the wrong, had left our territory and moved elsewhere. And because we said that the basis of the exercise of jurisdiction is the ability to serve him here, indirectly, we have said that notwithstanding that the wrong was done here, we will not have jurisdiction because the defendant is not present. So, assumed jurisdiction will, however, permit the plaintiff to pray our own court, to allow a notice of the writ to be served on the defendant wherever he is. This one is usually governed by rules of court. Rules of court. If you go to Order 10, Rule 1 of the High Court of Lagos Civil Procedure Rules, you find the assumed jurisdiction properly regulated there. If it is Federal High Court, you find the relevant order and rule of the Federal High Court. If it is a High Court of Federal Capital Territory, we also find something like that there. So we said it is a discretionary jurisdiction, by which we mean that you cannot claim it as of right. But every discretion of a court is exercised judicially and judiciously. The court does not just give it anyhow. The court must have thresholds, must have requirements to be satisfied. The rules of court themselves will state one particular requirement. That requirement is called localization factor. What do we mean by localization factor? Localization factor are factors that tend to connect the dispute with our territory. For example, if the subject matter of the case is a contract, our rules will say that the basis upon which the court might grant you leave to serve the writ on the defendant abroad is either that the contract was made in our territory or the contract was breached there, or that proper law of the contract is the law of our territory, etc., etc. Something special connecting the matter with our territory, okay? Such that you are able to tell the court that, look, if this defendant were not to have escaped from the territory, this is the place where he should have been sued. So the court will then look at it that, look, this matter basically is our matter. It is our law that will govern it. The facts occurred here, but the only reason is that the only reason why that is not possible is that our conditionality for jurisdiction as of right have not been met. So you table that before the court by way of ex parte application. As you are filing the cause of action, you are also filing the ex parte application. Okay? And the court may, in exercise of its discretion, agree with you and permit you to reach the defendant wherever he is with a notice of the writ. If there are treaties binding the forum with the place where the defendant is, you may serve the writ itself. Ordinarily, in the absence of there being a treaty, it is a notice of the writ. In other words, you are availing the defendant of the opportunity to come and defend a matter which is against him in the forum, failing which the court is ready to go on. So that is assumed jurisdiction. If you look at chapter 4 of my book, under the topic service of writ outside Nigeria, I discuss everything you need to know about assumed jurisdiction. Okay? If you consider what I have placed there to be too long, just understand that there are two important things to know about assumed jurisdiction. The first one is that the plaintiff who wants to beg the court to permit him to reach an out-of-state defendant must show something known as localization factor that establishes a special connection between the dispute and the forum. The second one is that whereas he must do that, it doesn't mean that once he's able to do that, the court must grant him the relief. The cases show that it is still a matter of discretion, and the judge might say that, well, you have met the requirement of localization factor, but we still don't think that this is the most proper place to institute this action. So those are the two conditionalities. Localization factor must be met, and if you go to order 10 rule 1, several localization factors depending on the type of dispute are listed. So any one of them must be met before the court can even consider your prayer. But even when those conditionalities have been met, it doesn't follow that the court must grant you the leave. That's why we said it is a discretion. And if you read some of the cases I explained in chapter 4 of my work, you will see that there are many occasions when the plaintiff have met localization factor, yet the court said it will not grant the relief. It will not grant the prayer. So that is that with assumed jurisdiction. The second category of discretionary jurisdiction is discretionary declining or declinature. Okay? Under this head, the plaintiff had already sued, and he had sued as of right because he has met the requirement. The last time we went over what is the requirement, we said if he's suing in a state court and the state is within Western or Northern Nigeria, all he needs to show is that he has been able to serve the writ that he obtained from the court or the defendant within the territory. But if he's suing in Eastern Nigeria, we explained that everything will depend on whether it is contract matter or non-contractual matter. And we explained conditionalities, any one of which if he meets, the case will be properly constituted in Eastern Nigeria. If the contract was made in Eastern Nigeria, even if it was breached outside Eastern Nigeria, if the contract was breached in Eastern Nigeria, even if it was made outside Eastern Nigeria, if Eastern Nigeria is the place where the contract ought to be performed, and finally, if the defendant resides in Eastern Nigeria. In any of these circumstances, Eastern Nigerian court will be assuming jurisdiction as of right. Okay? So, what we are saying is that under discretionary declarature, the plaintiff has properly filed the case because he has met our choice of jurisdiction requirement. But the defendant is saying that there's an alternative forum and is telling the court to stay the action so that the plaintiff should go to the alternative forum. Okay? So that application is known as application for stay. STAY, application for stay. And the grounds upon which an application for stay may be filed are three. The first one is what we call forum non-convenience. Forum non-convenience. I discussed forum non-convenience in chapter 4, and in particular, I cited a case. Okay, I cited a case where all the rules governing forum non-convenience were specified. The case is known as the case of Spiliada Maritime. Spiliada Maritime Corporation and Councillors. Read the case and understand the rule formulated by the court in that case. I discussed it in page 193 of my book. Okay? Spiliada Maritime Corporation and Councillors. Page 193 of the book titled Jurisdiction of Nigerian Courts in Causes with Foreign Elements. Okay? So let me give you a summary of the rules as formulated by the English courts. The first thing to do is that a stay on ground of forum non-convenience will only be granted where the court is satisfied that there is another available forum having competent jurisdiction to try the cause of action more suitably and for the interest of all the parties and the ends of justice. So the defendant is able to show to the court that this is not the only place he could have filed this matter. And for the convenience and the interest of justice, there is an alternative place, a much better place that he could have filed the action. Okay? Secondly, in order for the defendant to succeed, now that he has shown that there is an alternative forum, he must show that our own forum where he has instituted the action is not the natural forum. It's not the natural forum, by which he tries to show that the plaintiff is trying to secure procedural advantage. Possibly, is trying to make the cost of defending the matter so expensive that he, the defendant, would not bother to come. Okay? Thirdly, in deciding which is the natural forum between our own forum and the alternative forum, the court will look at the same issue of localization factor, which we said that under 10 Rule 1 highlights. So the court will look at if the tort occurred in state Y and the defendant is in state Y, why are you suing him in state X? Because the localization factor for tort is the place where the tort occurred. So if the place where the tort occurred is state X, and the defendant also resides in state X, but you have gone to sue the defendant in state Z, the defendant might be able to come to state Z to say, yes, he was able to serve me the writ in state Z, but state X is the more convenient forum. He will then be able to pray the court to state the action in state Z with a view to ensuring that you go to the proper forum, which is state X. Okay? So the court will now look at factors of convenience or expense, but they will also look at such matters as the law governing the particular transaction, the place where the parties reside, etc., etc. Every case will now turn on its own facts. We gave a case there, the case of Mark Shannon and Rockware Glass Limited. M was a Scotsman, resident in Scotland. He was injured in an accident at work in a factory in Scotland, owned by his employers, a company registered in England. On the advice of the English solicitors to his London-based trade union, he brought his action in England and not in Scotland, because the solicitor believed that he would get higher damages in England and that proceedings in Scotland would take longer to come to trial. But when it was shown that medical and other expert witnesses were equally available in Scotland and that the expense of trial in England would be appreciably greater than those of a trial in Scotland, the House of Lords unanimously ordered the English action to be stayed. So in other words, the case was treated in England, okay? The accident was in Scotland. The only connection of England to the matter was that the company was registered in England, okay? Now, you know, as we said, that the basis of jurisdiction in England is the possibility of serving the writ. So if the company was registered in England and has an office in England, it was easy to serve the company in England. But the defendant, that is the company, now defended against filing in England, complaining about convenience, complaining about expense and all of that. And the court states the action in England. Okay? You will see in page 196, I look at the case of the Jala Krishna and Connelly and RTZ Corporation. Look at the fact of those cases and see what are the conditions that the court will look at before granting this type of prayer. Then I went on to look at Nigerian cases. I look at the case of Bazoum and Clemency International and the case of Ll.M. Devin Co. Okay? So that is the first ground of discretionary declarature of jurisdiction. The second ground of discretionary declarature of jurisdiction is what is called exclusive foreign jurisdiction clause. Exclusive foreign jurisdiction clause. I discussed that one under the title Contractual Ouster of Jurisdiction from page 204 of my book, Contractual Ouster of Jurisdiction. What are we saying under this head? What we are saying is that in an international agreement, you will find that the parties have stipulated that when there is a dispute arising from their relationship, it is the court of state Z that they will go to. But the plaintiff, finding the defendant in state X, will rush to the court of state X, obtain a writ, and serve it on the defendant. You know that once he does that, jurisdiction of the court of state X have been constituted as of right. But the defendant will then come to the court and present to the court that the plaintiff was free in violation of his agreement not to sue there. So what should the court do? The procedure of private international law is that when that happens, the court is neither bound to discontinue the case nor bound to continue it. Rather, the court will exercise a discretion. So that is what we call contractual ouster of jurisdiction. And why we say it confers a discretion of the court. Okay? How does the court exercise this discretion to decline? The English cases have explained that very well. There is a case which I discussed in page 205 of my book. It's known as the Eleftheria. And the law that formulated the principles in that case is Lord Brandon. So the tests which he formulated are known as the Brandon test. Brandon test. Okay? Read what he said between page 206 and 207. So the first rule is that the court is neither bound to stay nor bound to continue. It's a matter of discretion. The second one is that as a general rule, the discretion will be exercised by granting a stay unless a strong cause for not doing it is shown. The burden of proving such strong cause is on the plaintiff. So once the defendant comes up and flags before the court an agreement between the plaintiff and the defendant, which says they should not go to that court, okay? He should not have sued in that court. The court would, first of all, realize that it has a discretion. Secondly, that discretion must be exercised in favor of the defendant, but that you will listen to the plaintiff. Mr. Plaintiff, what is the reason why, having agreed with Mr. Defendant that you will not come to this country to sue, you are nevertheless suing here? So that is the third rule. As a general rule, the plaintiff will now have the burden to establish special reason. Okay? And those special reasons are listed in Rule 5. If the plaintiff is able to show that the forum of action is the more convenient place than where both parties agree, the court might very well permit might very well permit the continuation of the action and refuse to grant. Many Nigerian cases have been decided on this point. In footnote 216 at page 210, I listed a number of cases. Adesanya and Palmline, Sona and Nordwind, Lara Obani and Jeko Shipping Line, Inlax Limited and Polish Ocean Line, etc., etc. In all of these cases, the court had applied the decision in the left area. In some of the cases, the court refused to grant the stay, but in others, the court granted the stay. In the case of Sona and Nordwind, the court, after applying the electoral rule, concluded that it was not going to grant a stay. The reason why the court did so was that under the Lord Brandon rule, there's a provision that one of the special circumstances that the plaintiff can establish is to show that if he were to discontinue the case here, before he will be able to sue in the other place, he will be caught by time bar. So, and in that particular case, the plaintiff was able to show that Germany, which is the choosing venue, that if he were to go to Germany at that time, given the facts, the matter will be caught by limitation. So the Supreme Court said, since he has met the requirement for jurisdiction in Nigeria, to tell him to discontinue so that he will have no remedy at all. Because if he were to go to the place that the parties agree that the matter will be filed, it will then be too late for him. So the court ordered that the case should go on. But in contrast, in another case, the case of Sonia and Lavina Corporation, Nika and Lavinia Corporation, which I also discussed in this book, the court ended up granting the stay because when the defendant presented the parties' agreement, the plaintiff was not able to say anything to show the special reason why the case must go on in Nigeria. So that is the way it works. Then the third ground is what we call lease alibi pendings. Lease alibi pendings. Lease alibi pending simply means there's a pending suit elsewhere. You will often find parallel litigation. Because more than one forum is connected with the matter, you can find a plaintiff instituting two actions, one in forum A and the second in forum B. Okay? You can also sometimes find a situation where You can also sometimes find a situation where the action in the plaintiff in forum A is the defendant in forum B, but under normal circumstances, it is the same case. It is a claim which the defendant would have been able to match with the plaintiff's claim in state A that the defendant had gone to institute afresh in state B. So we have concurrent and cross action. In the concurrent action, it is one party that sues in both fora. In the cross action, the plaintiff in forum A is the defendant in forum B. In both instances, the court can grant a stay once the court determines which is the proper venue between the two of them. Okay? So that is the plea of legal alibi pendings. But some of the time, the party who is approaching our own court may not ask us to discontinue our own case. It may ask us to bar the other party from continuing the case abroad. Okay? That is what is called anti-suit injunction. Anti-suit injunction. That is an injunction restraining a party from continuing an action in another country. We have had several occasions when that had happened. Very recently, in the case of Sunlick Petroleum and Shell, Shell had gone to UK to file an action in line with the parties' agreement. But Sunlick had filed an action in Nigeria. You know, it will be very easy for you to meet the requirement. All you need to do is proper service. Okay? So he had filed the action in Nigeria. But both the Nigerian and English court ordered Sunlink to discontinue the action in Nigeria because the parties' agreement, agreement stipulated England as the place of action. So the English court granted anti-suit injunction, and the Nigerian court obeyed it by saying, look, Mr. Sunlick, go to England. That's where you both agree that this case will go on in the first instance. So, in summary, lease alibi pendings can either result in an application for stay or in an anti-suit injunction, in an application for injunction to restrain the other parties from continuing a case which he has instituted elsewhere as a conditionality for him to be able to defend the case here. Okay? So that is discretionary jurisdiction. The last thing we want to say about jurisdiction is interstate. Distinction between international and interstate jurisdiction. That one is very easy to explain. We said the subject matter of litigation becomes of interest to us in this subject area because it has a foreign element. If that foreign element is a connection with another country of the world, then we say it is international. But if it is a connection with another state within the Nigerian Federation, we say it is interstate. Okay? So We are concerned with the interstate situation. If the matter is an interstate matter, and the defendant cannot be served within the state where it occurred, what are the options open to the plaintiff? The first option open to the plaintiff is to go to wherever the defendant is in Nigeria and sue him there. When he does that, he would have met the requirement of jurisdiction of right in those places. Okay? The second option, which is peculiar to interstate, not international, is contained in a statute known as Part 7 of the Sheriff and Civil Process Act. I discussed that statute in chapter 5 of my book. That is a statute that says that irrespective of where an action is instituted, you can serve the writ on the defendant in any other state within Nigeria. Okay? However, Part 7 of the Sheriff and Civil Process Act goes further to say some things that must be done. Section 97 says you must mark the writ. You must mark it with what is called special endorsement. A special endorsement is a clause on the face of the writ saying that this writ was obtained in the High Court of so state, but for service in the territory of so state. So that one will be put and the registrar will sign it. That's what we call special endorsement. Okay? Once that is done, the writ will then be served in the state where the defendant is as if the writ was filed in that state. Nothing else is required. You don't need to obtain leave. You don't need anything. Okay? However, if you have more than one party and one of the parties is located in the state where you are suing, then you are required to issue the writ concurrently. What do you mean by concurrently? The meaning is that the one that you are going to serve on the defendant that is resident in another state, you mark it as concurrent writ. You mark it with special endorsement. But the one that you are serving within the state where you have obtained the writ, you don't need to mark it with special endorsement. Okay? So you are permitted to issue the writ concurrently. So these are the requirements of Sheriff and Civil Process Act that therefore permit you to reach a defendant who is present in another state. That's why the statute is called a long-arm statute. A long-arm statute. Okay? You ordinarily will not be able to reach the defendant, but that statute has provided you the means by which you can reach that defendant. That's why it is called a long-arm statute. Okay? The Sheriff and Civil Process Act, you must know, applies only to writ obtained from state courts. It cannot apply to writ obtained from the Federal High Court. Although we used to have a decision where the Supreme Court mistakenly said it applied to writ obtained from Federal High Court, but the rules of court have long corrected that error. Today, if you are obtaining a writ from one judicial division of the Federal High Court, for purpose of service in another judicial division, it is the rules of the Federal High Court that you look at. So sometimes the rules will tell you that you should obtain leave, and whatever it says is what you should do. But you don't look at Sheriff and Civil Process Act. The reason is that there is only one Federal High Court. And so the issue of state judicial division is what it is, mere judicial division or local venue rule. But because each constituent state of the Nigerian Federation is a sub-sovereign of its own, you cannot obtain a writ in Lagos and serve it in Oyo as if you are ordinarily serving it in Lagos. That is why the Sheriff and Civil Process Act regulates that one. And you cannot look at the rules of the High Court of Lagos. It cannot solve the problem because the rules of the High Court of Lagos is only concerned with which judicial division will you go and file your action, whether Ikeja or Ikorodu. But if you are looking at two venues, Ikeja or Ibadan, definitely neither the civil procedure rule of Oyo State or that of Lagos can solve the problem. That is where Sheriff and Civil Process come in. And that's where Sheriff and Civil Process Act is called a long-arm statute. So in summary, the long-arm statute is only relevant for writs obtained in state courts. If it is obtained in Federal High Court, because in law there is only one Federal High Court, the state branches of the Federal High Court are not separate courts, they are judicial divisions. So it is only the rules, civil procedure rules of the only one Federal Court that we have that you are going to look at to see what you can do if you have filed action in FCT Abuja, but defendant is in Nasarawa. You have filed action in the Federal High Court, FCT Abuja, defendant is in Nasarawa, or you have filed action in the Federal High Court Ibadan, but defendant is in Akure. So in all of this, it is the Federal High Court Civil Procedure Rule that will guide you. And I think what the Federal High Court Civil Procedure Rule says in that circumstance is that you should obtain leave of the court. Whereas the Sheriff and Civil Process Act does not require you to obtain leave. So for our friends in cyberspace, we are saying that if there is an online contract and the contract is breached and you want to go to court, okay? If the type of contract is the type that you will litigate in the Federal High Court, you don't need any assistance from the Sheriff and Civil Process Act. So if the defendant was, for example, in Enugu, when you exchange your correspondence and you decide to go to Federal High Court, Lagos, it is the civil procedural rules of the Federal High Court, Lagos that you are going to look at, not Sheriff and Civil Process Act. But if it's a type of subject matter that falls within state courts jurisdiction, and you decide to come to Lagos High Court, and the defendant is in Ibadan or Enugu, you have to solicit the assistance of the Part 7 of the Sheriff and Civil Process Act to be able to reach the defendant. And the relevant provision is what I have read to you. You have to comply with Section 96, 97. And if there are two defendants, one in Lagos and the other in Enugu, you have to satisfy Section 98 also. So I think on that note, I have finished jurisdiction. You can read my book, read chapters 2, 3, 4, and 5. It will be very useful to you in understanding choice of jurisdiction rule. And the last thing we are going to be talking about is enforcement of judgments. And I think in 1 or 2 lectures, I will round that up. I will round enforcement of judgment up maybe next week. Any question?
Yes, sir. Good evening, sir.
Yeah, good evening.
Sir, my question is around the endorsements, the special endorsements to be made on the process. So is it like typing the endorsement, or one has to use a biro, a red biro or a
No,
blue
no, no,
biro to
no,
make
no.
such endorsement, sir?
It will be typed on the read. It will
Okay,
type
sir.
on the read and the
Okay,
registrar will
sir.
sign it. I gave you the wordings of the endorsement in my book. Chapter 5 of my book. It will just say that the writ was obtained in the so state high court for service in so state. And the registrar will sign it. That's special endorsement.
Thank you,
Is it
sir.
clear?
Yes, sir. Thank you very much, sir.
Mm. So I see you people next week. If there's any other question, please ask me next week. But we are moving to enforcement of falling judgment as from next week.
Thank you, Prof.
Yeah.
Thank you, sir.
You're welcome.